Hello and welcome back to the Waite of the Law podcast. For this episode, I'm with my colleague Rachel Mayston from our wills, estate and tax planning team to talk about the crossover between family law and estate tax planning. So Rachel, how long have you been at the firm now?
I've been at the firm 7 years and I've been qualified 7 years. So I joined on qualification.
That has gone very quickly.
It's gone really quickly. I can't believe it.
And I think that means that I've been at the firm for twice as long as that.
Oh, really? Yeah.
Which makes me feel quite old.
Everybody's been here a long time.
Yeah. I think that's a good thing.
Yeah.
So what do you do on a day-to-day basis?
So essentially, I help people to plan for their death, making wills and things like that. I help manage their tax exposure and just plan the transfer of wealth between generations.
And do you find it quite difficult to have those initial conversations about, I mean, I suppose you're used to it now, but those conversations about death? Because I know when we see clients and we're saying to them, right, you need to think about your will because you're getting divorced.
Yeah.
Or we're talking about severing the joint tenancy, which is how you own a property. I think we're always, as family lawyers, a bit reluctant to use the word death.
Yeah.
And we sort of skirt around it and say, you know, something happens to you or something happens to your spouse while this is all going on.
Yeah.
But I suppose it's something you have to talk about.
I think I'm desensitised to it thoroughly.
Yeah.
And actually, I think the longer you do it, the more you need to make sure you remember that it's a sensitive topic.
Yeah.
Because some clients do struggle with it.
Yeah.
You know, I've had clients that are quite upset trying to plan that aspect.
Yeah.
But it depends what life stage they're in and what they're trying to plan.
Yeah.
If they're just making gifts to their kids, then they're more relaxed. If it's near their death or, you know, in a divorce, that's a really tricky time.
Yeah.
And that can be emotional. And then
I think that's the thing, isn't it? If you're getting divorced and you're also then having to plan for what might happen if something happens to you, it's a double whammy because you're, you know, everything's been pulled out, the rug's been pulled out. You didn't see your life when you're getting divorced. It's not how people planned. They weren't expecting to be in that position, and they're suddenly having to split their assets. They're worried about how they're going to manage financially because they've gone from income of potentially two people and assets shared between the two of them to having to, you know, split them and go their separate ways. So generally, from my perspective, or from the family team's perspective, we obviously get in touch with you when clients are thinking about getting divorced, because we will say to them, you need to think about what you want to happen if something were to happen to you before the divorce is finalised.
Yeah.
So we do send quite a lot of clients your way in that scenario, don't we?
Yeah. Well, and a lot of people become very concerned that when they start the divorce proceedings or it gets on the card, they think, actually, if I die, I really don't want all of my assets to end up in my spouse's hand. I want to make sure they go to the children, particularly if there's other partners on the scene at that point. So, that's when we generally hear from them. And sometimes it will be at the end, but we try to prepare wills that will last from when they begin proceedings until long after the divorce. So the normal suggestion is a discretionary trust will.
Yeah.
It's really flexible. There's some tax planning elements that can be done with a discretionary trust will, but the major benefit is that it's a vehicle that would hold their estate, and it has a class of potential beneficiaries. So that would be usually their children, grandchildren, and it would also be their spouse. And the spouse isn't entitled to anything.
Yeah.
But if something really tragic happens and they die between starting proceedings and the divorce being complete, it gives their trustees the chance to protect wealth for the children, but also negotiate with the spouse and their lawyers if the financial settlement isn't agreed.
Yeah, and I think that's really helpful for people to understand, and to understand that it's something that they can do and then remains in place, rather than having to do something in contemplation of divorce and then something once you're divorced.
Yeah.
Because obviously that, I think as well, when you're having to involve solicitors because you're going through an event like a divorce that's just pretty unpleasant, the less interaction you have to have with them once it's done, the better, because I think most of our clients are quite pleased not to hear from it. You know, once it's all over and done with, they don't really want to hear from us again. So I think the fact that the will is in place then, and and
they can have a break from the lawyers for a bit.
I think that's quite helpful.
Normally we'd set up the will with the trust in it, and then they have a letter of wishes on the side, and that's the boots on the ground with the instructions, and clients will set out in their letter of wishes anything that they would want to happen if they die before the divorce is complete and after. So before the divorce is complete, it might say keep as much as you possibly can for the children, but you can negotiate. And then after, it will say everything for the children, nothing for the spouse, and the spouse can be excluded as a beneficiary.
Yeah, and I think letters of wishes are something we will get asked by clients, if they've got minor children, what will happen if something happens to me, about where the children will live, how much contact they'll have with the other party. And it becomes problematic if the other parent isn't pulling their weight, or they've got concerns about, say, they've got a problem with alcohol, or there's a reason why they wouldn't want the children, they didn't feel that the children would be safe living with them. But that parent is obviously, if something happens to them, the parent that survives will be the only person with parental responsibility. And so we will also say to them, talk to your lawyer preparing your will, because at least in the letter of wishes you can put some information in about your views on it. Yeah. Does that happen quite a lot, that people will put in what they want to happen with their children, not just the finances?
Yeah, well, letters of wishes can range from 3 paragraphs to 6 pages or more, and they will sometimes, especially when people are going through a divorce, there will be quite a lot usually on all the elements around their children, their education, where they'd like them to live, who they'd like to look after them, what religion they should be brought up in, all sorts of, criteria. And then there will be information about the transfer of wealth. So at what age they would expect outright payments to be made to children, whether they want them to be at all, if they were concerned about outright payments being made to the children and then the children just passing them straight on to the other spouse. The trust can go on, it can go on for 125 years from the death. So it will long outlive the children, presumably, unless medicine improves. So the trustees can keep the money wrapped up. It can either be broken apart, the trust, straight away, or it can be kept running. So if the children are minors, it's a protective wrapper. Whereas if the will had left funds outright to the children and they were minors, then funds could be paid directly to the surviving parent.
I think what we say to clients about the letter of wishes when it comes to the children is that it isn't going to, because they've said in the letter of wishes that they don't, for these reasons, they don't want the children or the child to live with the other parent. It doesn't mean that is exactly what will happen, but it is something that a court, when they're looking at where a child should live, if they say grandparents are saying they should live with me, other parents say no, they should live with me, the letter of wishes and the views of the parent that's not there anymore does actually, it carries weight, but it's not conclusive. It doesn't mean that's what a judge is going to do. But I think it gives that parent as well a feeling that they have, well, not just about what will happen with the children, but about the finances as well. It gives them a feeling that they've got some control in a situation where, if you're going through a divorce and you're worried about dying, you feel pretty out of control. And so it's the best thing that you can do in terms of putting something in writing.
And it can be, the other advantage to it is it can be changed as often as the client likes. The client can edit it at home and send us a new one. They only need to sign and date it, whereas the will requires witnessing. And the letter of wishes can get away with being home drafted in a way that a will
so it's not
really
something
can't.
You have to draft. You don't have to. They don't have to put it in writing and then you type it up and change it.
Exactly. A lot of people will get us to do a first draft to give them a steer on where to go. And then they will edit and add all of the personal details and things like that.
And have you ever had to say this is just too long and some of it is just not right?
No, I've never actually had. We will say, are you sure you want to include that? It's the last thing you're going to say to somebody. But generally, most people they're quite practical documents.
And quite mindful of the impact it might have on the person reading it.
We do take sealed envelopes for people, so sometimes they'll write a letter to a family member in a sealed envelope and name it, and we'll just hand it over on their death. And I think sometimes, if that's not positive, that could be quite an upsetting experience. But most people, I think, aren't going down that road.
No.
I hope.
No, I hope not too. And then in terms of the other sort of interaction, I think, because that's one of the biggest interactions our teams have, is the wills and the contemplation of divorce and making sure their wills are in place. And we also obviously talk to them about severing the joint tenancy, the way that they own the family home, which most married couples own a property as joint tenants, and we're saying, well, you should sever it so it passes under the terms of your will. That naturally pushes them then to go and get advice about a will. But we also interact, I think, in terms of the wealth preservation side of things. So when you're probably more coming from your perspective, when you're seeing clients who are wanting to gift money to their children, or loan money to their children, and they want to make sure it's protected if anything happens because that child's in a relationship, then you might pass them to us to talk about cohabitation agreements, prenuptial agreements.
Well, so we quite often will interact when we try to decide what's the most practical or the best option here. Will it be a declaration of trust or a cohab agreement? So the declaration of trust is normally quite a simple vehicle, and we'll deal purely with the finances. And it might be, if daughter has a girlfriend and they purchase a property and the parent gives the daughter 100,000 and the new partner brings in 20,000, you can have a simple declaration of trust that says if they sell, then the daughter gets back her 100 and he gets back his 20, and the rest is split however you like. And you can make the finances as complicated as you like. They can have floating shares, different percentages, different weighting, so they can get more and more complicated. They can get to a certain stage where they really do need to then go straight into a cohabitation agreement. There's too many things that they try to bring in. And sometimes people will try to bring in an element of a will, what people are. I had sometimes with the creation of ChatGPT, we get AI drafted documents, and was sent one the other day, and it was a combination of a declaration of trust, a will, and a cohab agreement.
Interesting.
It
doesn't quite work.
This isn't going to work. We need to do that differently.
Because we see, obviously, we'll have clients who are going through a divorce, or if they're unmarried, they're going through a separation, and they've been given money by the parents or the grandparents or a family member, and there's one person's recollection is that it's a gift and the other person's recollection is that it's a loan, and if we can't resolve that, we end up before a judge who has to decide, if there's nothing in writing, then it's just based on who the judge believes on the day, and whether and sometimes those parents have to also, if they're the ones gifting it, have to be joined to the proceedings, and it becomes incredibly expensive and just really unpleasant. So if people are gifting money to children, it's worth them having thinking about how best to protect that. And if they're getting married, then they can have a prenuptial agreement that protects the family money, which then goes hand in hand with any tax planning that those parents or grandparents are doing. And it's just, I think we work together in that sense to try and help both the parents and the children to see how it can work. But it's something that I think if more people knew about it and what it means when you're gifting money to your children or your grandchildren, if they then live with somebody or get married to somebody and that doesn't work out, it's just trying to get people to understand that is something to think about.
Something to protect.
Because most people don't want it to pass outside of the family.
People talk about bloodlines. That's what they all, keeping money in the bloodline. And I can understand if someone's had a 2-year relationship, they don't want to see half of the deposit they've given disappear.
Absolutely.
So yes, putting things in writing, and ideally with the advice of a lawyer. It's normally.
And so, but going right back to basics, because obviously we've talked about making wills, but we haven't really explained. So what would happen if somebody came to you and said, right, I need to think about a will? How would that process work?
Yeah. Well, we generally talk about what their family looks like and what their estate is made up of. And then we work from what their ultimate aim is backwards. And normally that's what then begins a conversation about lifetime giving as well, when we work out what they want to kind of end up giving. And we often find that people have already started making gifts. But it usually starts with a meeting, and we discuss their instructions, get to the bottom of what they want to do, and then we start drafting wills.
How long does it normally, I mean, I know that's a difficult question because it depends on the clients and how complicated the will is, but how long does it normally take from that sort of initial, I'd like you to prepare my will, to actually getting one in place?
So if the client is kind of quick and responsive too, then I say too because we are.
Of course.
Yeah, then 4 weeks, because we've got to fit them in with the appointment. We then send them a note saying, right, this is what we've discussed, this is what we're going to do for you. If they read that and go, yep, go, then maximum 2 weeks to get the will out to them.
Yeah.
And again, if they approve it straight away, then it's just get them in for signing.
Yeah. And then once they've signed it, do most people leave their wills here to be held by us?
Yeah, most people do. We have a storage facility that's secure and safe, and so people want to avoid the fire scenario or the flooding scenario, or the destroying their will in a kind of fit of rage scenario as well. Yeah. If they've got to phone us and discuss it, then gives people time to think about things.
And I suppose, unless, I mean, some people maybe aren't that organised, you could lose it. If you were holding it at home. Your will, I can imagine I would do that if I was holding it at home. There's a lot of paperwork in my house.
And there's a service where people search for wills, so it happens a lot because it's a service where people search for wills, and this service will email all the law firms in the local vicinity to say, are you holding a will for this person? And we get them, a fair amount. So there's people are still keeping their wills at home, and they're getting lost, or people aren't making wills. Or they're writing their wills, on a scrap of paper and not actually formalising them.
But obviously we wouldn't advise to do that, would we?
That's a bad idea. Yeah.
Okay, well, thank you very much. It's been very interesting. I think I've learnt a couple of new things, so that's always good.
Yeah.
Thanks, Rachel.